you have any questions, sir? You're 21 and you have all these priors? What the heck, man?
Everybody perfect.
Don't say anything. It's a rhetorical question. 1, 2, 3, 4. Assault, criminal trespass, attempted assault on a public servant, possession of a controlled substance, unauthorized absence from a correctional facility, felony retaliation, assault, felony assault, assault of a public servant, assault of a public servant, harassment of a public servant, assault of a public servant, now 2 counts of a burglary of a motor vehicle and a robbery. Something's not taking. Let's do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Please.
On May 22nd, 2024, officers responded to an apartment complex and observed the defendant detained by citizens. Complainant advised that he was inside of his apartment and observed the defendant sitting in the driver's seat of his vehicle. Complainant got his brother, went outside, and observed the defendant walking away. Complainant and his brother attempted to stop the defendant and got into a physical altercation with him. And at one point, defendant pepper sprayed complainant's brother. 3 other tenants heard the commotion and came outside to also find that their vehicles had been broken into and they were unable to start due to damage to their control panels. One complainant advised that his phone was taken from his car. Defendant was found with the phone and a programming device used to start cars without their keys, and defendant admitted to burglarizing the vehicles.
Was the robbery due to the pepper spray?
One moment.
Everything I was already taken. I don't see where the robbery comes in. He took everything from the vehicle.
Yes, Judge. It is charged. It is pled as spraying the complainant. The robbery.
With the intent to obtain and maintain control of the property, intentionally or knowingly and recklessly cause the bodily injury by spraying the complainant with a chemical agent. Not only that, you're enhanced with the felony retaliation. So are we looking at a 15 to life? Dave, is this a 15 to life case? Our case number is 2511-521. Fifth, it's elevated to a 5 to life. I don't know about giving you a PR bond, man. All I care about is public safety, Mr. Haywood, and I don't know if we get it with you. I'm ordering you now as a condition of your bond, if you get out, to remain under home confinement, to have a GPS monitor, not to have any contact with the complaining witness, and not to go within 1,000 feet of this apartment. It's an apartment complex?
Yes, sir.
Not to go within 1,000 feet of this apartment complex. No weapons, undergo random drug testing for alcohol and any kind of dope. Your bond now is set at $15,000 in the robbery case. They gave you PR bonds with ours. I don't know if I'm down with that, you know, not with that kind of criminal history and the fact that he just had an assault dismissed of servant. So guys, please, home confinement, no weapons.
He does work at a tire shop.
Priors at 21, and now you're charged with 3 cases, one of those being a 5 to life first-degree felony. Ha! I'm sorry, Alan. He scares me. Just bottom line. My only concern is public safety, Mr. Haywood. That's all I care about in this life. You know, you live in Texas. You don't live in Montana, Wyoming. People like their guns and they like their cars. Not a month ago, someone died from a gunshot because of breaking into a car. And the way you look at me now tells me what I can look forward to. All right. Please don't send them down because we need them to sign some conditions, please. There's no co-defendant, or was there a co-defendant? If there is no contact with the co-defendants.
No co-defendant.
No co-defendants, there's just him? Got it. You were charged with indecent exposure. You wanted to do the PC on indecent?
Yes, Your Honor.
You're charged with indecent exposure. You are facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
May 26, 2024, officers were dispatched to a defendant touching his private area at the Metro-owned downtown transit center located on 1900 Main Street, Harris County, Texas. The officer was advised by Metro Dispatch that the complainant called and stated that the defendant was exposing himself to her. Complainant told officers that the defendant was a black male in a blue hoodie and boarded a Metro bus, and then ultimately pointed the bus that he had boarded. Matching the description, and complainant witness confirmed that that was the same person. Complainant stated that the defendant followed her from across the street, pulled out his penis, and started exposing it to her and looking at her. She further stated that the defendant began stroking his penis back and forth with his hands, looking at her without speaking, approximately 5 to 10 feet away. The complainant stated that she was unable to tell if he was erect, but she was able to clearly see his penis as he was stroking.
Your Honor, after speaking with my client, the officers approached 2 males. I have to wait on body cam to see what the other male looked like, but my client's saying that wasn't him. He just.
I mean, I don't know. I think that there's probable cause to go forward now. Mr. Lane. Mr. Lane, we will get the body cam to ensure and see if that is in fact you, because we don't know. All we know is that we have someone that has identified you. I will try to have them get the butt. Do you have it now? What evidence do you have now?
This is a brand new case, Your Honor. This is the 26th, so I don't know. There's nothing in yet, so I literally just wrote this up before I came to court.
Okay, I will, Mr. Lane, I will try to have them get the information and the body cams as quick as possible so we can verify that it is you. I would say let's try hopefully a week. The problem is that I can't give you a PR bond because you continue to take off on us. I had your evading arrest at 7503 because we can't get you here. So, okay. Do you have any questions, sir? Right now, you're on probation for a felon in possession of a weapon. You're also on probation for possession of a controlled substance in the felony case. You picked up in April with us, you picked up an assault bodily injury. You have literally been given 3 PR bonds and you continue to take off.
I didn't get PR bonds, sir.
But you have. I'm showing that you failed to appear 516.
I just got a PR bond, sir. Excuse me.
Listen to Dave.
So Roberto, please don't go. Okay, so I have 3 different occasions that you failed to appear. I cannot, in my good conscience, give you a PR bond when you continue to take off because I know If we give you another PR bond, what's going to happen?
I haven't had a PR bond, sir. I bonded out, and it's the only reason I'm back right here right now, sir, is because someone took their name off the bond. I haven't did anything else and gotten in trouble. Someone just took their name off the bond because I couldn't get a co-signer. That's the only reason I'm back in jail right now.
I also have that you have failed to appear on 3 different occasions. Okay.
I haven't.
So so what we're doing, regardless, your bonds are set at $55,000 upstairs.
And I'm gonna make the bond this Saturday. That way I can take care of this stuff
If you
better.
make the bond, I am now going to make you wear a GPS monitor so I know where you are at all times, okay?
Yes, sir.
But I cannot give you a PR bond in this case, okay? Because you just don't show up when we ask you to show up. So regardless, you have Greg representing you now. If you do get out, please stay in contact with him. If you get out, you post bond and you jet on me again, Ms. Gilardoni, I'm going to triple, if not quadruple the bond.
Thank
You
you, sir.
understand?
Yes, sir.
All we're asking you to do is show up.
All right.
That's it. And stay out of trouble.
All right.
Okay?
Yes, sir.
I know that the felony courts are trying to have you evaluated as well. Do it, because if you don't, the only thing it does is it prolongs your case even more.
Okay.
Okay?
Yes, sir.
I think that we're okay. I don't think that there's,
Oh, Your Honor, thank you.
yeah. So,
I don't think I'm not showing a felony court date for her, but then I was showing,
I am showing 7/29.
okay, you got that 7/29 as a felony.
Your court date for your felony cases are July 29th.
Yes,
Okay?
sir.
We don't do that long. Okay? We'll do just 30 days and then we'll come back and then go from there.
Okay, Your Honor, perfect.
Thanks, Steve. Appreciate it. All right. Good luck, Ms. Gallardo.
All right. Thank you.
Yes, ma'am. I'm gonna tell you now, you ever take off on me again, I will put you over my knee and I'm gonna spank you with so much of a high bond, you're gonna go flip and split into 3. Do you understand, Mr. Chavez?
Sir.
As it stands now, I'm rolling this case to tomorrow to see whether they're gonna honor their offer. And if not, then I'm just gonna set your case for trial. Be back here tomorrow and we'll see if he can still finagle this thing for you. If so, you've got 2 weeks to complete this thing. You ain't got it done, I will set your case immediately for trial.
May I reset for, and I just come back?
No, I'm not gonna, no, I want to make sure that he's good. It's 600 days old. You gonna be here tomorrow?
Yes, I'll be here tomorrow. Yes,
Okay.
I certainly will.
Doesn't matter to me if it's a little inconvenience to you, Mr. Chavez. It's 600 days old. I want to know exactly what's gonna happen. Do you understand? See you tomorrow.
Just hold off right there.
What an absolutely intense courtroom session this was, full of tension, contradictions, and some deeply revealing moments about both defendants and the justice system as a whole. Yeah, let's break this down professionally and clearly because there's a lot packed into these few minutes. We begin with the first defendant, only 21 years old, yet already carrying a criminal record that spans multiple assaults, trespassing, retaliation, drug-related offenses, and now burglaries that escalated into a robbery charge once pepper spray entered the equation. The judge's reaction isn't exaggerated. In Texas, when property crimes involve bodily injury or violent force, the legal classification shifts dramatically. The moment the defendant pepper sprayed one of the tenants during the confrontation, the charge crossed into robbery territory, which legally requires intent to take property while causing bodily harm or fear. That single action could be the difference between a short sentence and a life-changing felony time range of 5 years to life. The judge's skepticism about granting a PR bond is rooted in public safety, a key theme throughout this hearing. Courts weigh community risk, especially when a defendant's criminal history shows repeated violence. The judge specifically sets home confinement, GPS monitoring, and strict no-contact rules to protect both the complainants and the broader public. This isn't just punitive, it's preventative. The judge even references a recent fatal incident involving a car break-in, clearly tying real community risks into their bond decision. Then, the courtroom shifts to the second defendant, charged with indecent exposure and already facing previous evading and probation violations. This part is important legally. Probable cause can be established solely on a complainant's direct identification combined with officer reports, even before body cam footage is reviewed. The judge acknowledges this, stating that because an eyewitness has identified him, the case proceeds forward despite the limited evidence available at the moment. But the biggest issue for this defendant isn't the charge, it's the pattern of failing to appear. Judges often say that they're less concerned with the crime itself and more concerned with whether a defendant can reliably return to court. The transcript repeatedly shows the judge pointing out multiple no-shows, reminding him that missed court appearances directly prevent PR bond eligibility. A PR bond is based on trust, and here, that trust has repeatedly been broken. The judge's tone is stern, even parental at moments, especially when warning that future failures to appear could result in tripled or quadrupled bond amounts. The message is clear: showing up is the minimum expectation, and anything less shuts down leniency options. This session also shows us the human side of courtroom proceedings. The judge expresses fear, frustration, and caution, not out of bias, but out of responsibility. Public safety, defendant accountability, and proper case progression are the guiding principles here. And we see that play out in real time. So what are the big takeaways from this case? Criminal history matters. Even young defendants face serious consequences when patterns emerge. Bodily injury transforms property crimes into violent felonies. Missing court dates destroys chances for PR bonds. Judges balance fairness with community protection. Every action during an arrest, like pepper spraying someone, can elevate charges dramatically. If you found this case as shocking as we did, make sure to hit that like button, drop your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. Your support helps us continue bringing real cases, real consequences, and real legal insights directly to you.